the presiding officer of this proceeding could determine a waiver or the applicability of executive privilege would be quite a step precedent. There's no historic precedent that would justify it. But there's something else. If we get to the point of witnesses, then, for instance, if one of the witnesses to be called were by the president's lawyers was Adam Schiff, in the role basically of Ken Starr. Ken Starr presented the report, made the presentation before the House of Representatives, had about 12 hours of questioning, I believe, is what Judge Starr had. If Representative Schiff was called as a witness, would in fact then issues of speech and debate clause privilege be litigated and decided by the presiding officer, or would it go to court, or maybe they would waive it? But those would be the kind of issues that would be very, very significant. Senator Graham presented a hypothetical which Manager Schiff said, well, that's not really the hypothetical, but hypotheticals actually are that. They're hypotheticals. But I'll give you, to use Manager Schiff's words, he talked about it would be wrong if the FBI or the Department of Justice was starting a political investigation of someone's political opponent. And I'm thinking to myself, but isn't that exactly what happened? The Department of Justice and the FBI engaged in an investigation of the candidate for President of the United States when they started their operation called Crossfire Hurricane. He said it would be targeting a rival. Well, that's what that did. He said it would be calling for foreign assistance in that. Well, in the particular facts of Crossfire Hurricane, it has been well established now that, in fact, Fusion GPS utilized the services of a former foreign intelligence officer, Christopher Steele, to put together a dossier, and that Christopher Steele relied on his network of resources around the globe, including in Russia and other places, to put together this dossier, which then James Comey said was unverified and salacious, but yet it was the basis upon which the Department of Justice and the FBI obtained FISA warrants, and this was in 2016, against a rival campaign. So we don't have to do hypotheticals. That's precisely the situation. But to take it an additional step, this idea that a witness will be called, if this body decides to go to witnesses, that a witness will be called, would be a violation of fundamental fairness. Of course, if witnesses are called by the House managers through that motion, well, the President's counsel would have the opportunity to call witnesses as well, which we would. Thank you, Mr. Chief Justice.
Thank you, counsel. Oh, Senator?
Mr. Chief Justice, I send a question to the
California,
desk.
of course.
Thank you.
The question from Senator Harris is for the House managers. President Nixon said, quote, "When the president does it, that means that it is not illegal," end quote. Before he was elected, President Trump said, quote, "When you're a star, they let you do it. You can do anything," end quote. After he was elected, President Trump said that Article 2 of the Constitution gives him, quote, "the right to do whatever he wants as president," end quote. These statements suggest that each of them believed that the president is above the law, a belief reflected in the improper actions that both presidents took to effect their re-election campaigns. If the Senate fails to hold the president accountable for misconduct, how would that undermine the integrity of our system of justice?
Mr. Chief Justice, Senators, I think this is exactly the fear. I think if you look at the pattern in this president's conduct and his words, what you see is a president who identifies the state as being himself. When the president talks about people that report his wrongdoing, for example, when he describes a whistleblower as a traitor or a spy, the only way you can conceive of someone who reports wrongdoing as committing a crime against the country is if you believe that you are synonymous with the country, that any report of wrongdoing against the president, the person of the president, is a treasonous act. It is the kind of mentality that says, under Article 2, I can do whatever I want, that I'm allowed to fight all subpoenas. Now, counsel has given a variety of explanations for the fighting of all subpoenas. They might have a plausible argument if the administration had given hundreds of documents but reserved some and made a claim of privilege, or the administration has said, we'll allow these witnesses to testify, but with these witnesses, with these particular questions, we want to assert a privilege. But of course, that's not what was done here. What we have instead is a shifting series of rationales and explanations and duplicitous arguments, some made in court and some made here. You have the argument that the subpoenas aren't valid before the House resolution, and then with respect to subpoenas issued after the House resolution, like to Mulvaney, well, those are no good either. You have the argument made that we have absolute immunity, and the court that addresses this says, no, you don't. You're not a king. That argument may be thought of with favor by various presidents over history. It has never been supported by any court in the land. There's no constitutional support for that either. Documents that are being released right now as we sit here, and it's a mystery to the country and it's a mystery to some of us, how are private litigants able to get documents through the Freedom of Information Act that the administration has withheld from Congress? If they were operating in any good faith, would that be the case? And of course the answer is no. What we have instead is we're going to claim absolute immunity even though the court says that doesn't exist. Now, they said, well, the House withdrew the subpoena on Dr. Kupperman. Why would they withdraw the subpoena on Dr. Kupperman when he was only threatening to tie you up endlessly in court? Now, we suggested to counsel for Dr. Kupperman that if they had a good faith concern about testifying, if this was really good faith and it wasn't just a stratagem to delay, if it wasn't just part of the president's wholesale fight all subpoenas, they didn't need to file separate litigation because there was actually a case already in court involving Don McGahn on that very subject that was ripe for decision. Indeed, the decision would come out very shortly thereafter. And we said, let's just agree to be bound by what the McGahn court decides. Well, they didn't want to do that, and it became obvious once the McGahn court decision came out because the McGahn court said, there's no absolute immunity, you must testify. And by the way, if you think people involved in national security, i.e. Dr. Kupperman and John Bolton, if you're listening, if you think you're somehow absolutely immune, you're not. So did Dr. Kupperman said, well, now I have the comfort I needed because the court has weighed in? The answer is, of course not. Now, counsel says, well, we might have gotten a quick judgment in Kupperman. Yeah, in the lower court. Do any of you believe for a single minute they wouldn't appeal to the Court of Appeals and to the Supreme Court, and the Supreme Court struck down the absolute immunity argument? They wouldn't be back in the district court saying, okay, he's not absolutely immune anymore, but we're going to claim executive privilege over specific conversations that go to the president's wrongdoing. Okay, that is the sign of a president who believes he is above the law, that Article 2 empowers him to do anything he wants. And I'll say this, if you accept that argument, if you accept the argument that the President of the United States can tell you to pound sand when you try to investigate his wrongdoing, there will be no force behind any Senate subpoena in the future. The fighting all subpoenas started before the impeachment. If you allow a president to obstruct Congress so completely in a way that Nixon could never have contemplated, nor would the Congress of that day have allowed, you will eviscerate your own oversight capability, not
Thank
just
you,
in
counsel.
impeachments.
The majority leader is recognized.
I suggest that we resume at 4 o'clock.
Without objection, so ordered.